I want to talk about the typical timelines and general steps in a matter where you're charged with a firearm or weapons offense in Ontario, or Canada for that matter, but my focus is in Ontario. So this is very important for clients to understand if they're charged with a weapons or firearm offense. And there's very serious weapons offenses, and there are very serious firearms offenses and very minor ones. So I'm gonna focus first on the minor ones, where it's a summary conviction election. You have a trial. If it goes to trial, it's in the Ontario Court of Justice, our lower court. So what happens? So let's take the hypothetical. You're charged with a firearm or weapons offense today. That's a more minor charge. Crown's electing summarily. What do we do? Well, first of all, in hiring us, we're going to have you sign a piece of paper called a designation. That gets filed with the court. We're your lawyers now, okay? And we order the disclosure. That's all the police reports, witness statements, test firing of the weapon, the pictures, photographs, video, whatever there is in the possession of the police goes to the Crown. The Crown's required to give every scrap of that evidence to us, photocopies of it, you name it, DVDs of surveillance, wiretaps, whatever it is, they have to give to us. So once we have all of those documents, I'm in a position to review those carefully and kind of formulate a tentative opinion about the strengths and weaknesses of the Crown's case, whether they can prove the case, what your options are, whether I think you should consider pleading guilty because the case is too overwhelming, and what type of deals the Crown might offer you. Once I've finished that, and that might take time depending on the complexity of the case, or it might not take a lot of time, it might take a day if it's just a more minor case, I'm in a position to meet with you and review that with you, have you review it as well on a different date, have you sit down with disclosure, fulsomely review you, give you all of your options, talk about the strengths and weaknesses of the Crown case, whether I think the matter is triable, whether we can win, whether the Crown's going to offer us a good deal in my mind, whether we can negotiate something. And based on all of that, you tell me what you'd like me to do. I give you legal advice, you tell me what you do. So you might say to me, for example, Mike, it's an overwhelming case. I want you to negotiate the best deal you can with the Crown, and I'll take my lumps. Or you know what, Mike? You're telling me I've got a pretty good shot at winning this. It's a possession of a weapon for a purpose dangerous to public peace, for example, and I'm not guilty. According, you don't see a lot of strength to the Crown's case, so we should head to trial unless they offer me a great deal, like a peace bond, or better yet, just withdraw the charge. Armed with all that information and your personal background and history, because it's important I go through that, I start the process of meeting with the Crown, which is called a Crown PreTrial. And again, I have all of these discussions with the Crown about whether the matter is going to trial, trial management issues, witnesses, who I'm calling, who the Crown's calling to manage court time. I'm also receiving and trying to convince the Crown perhaps to withdraw the charge, perhaps to provide a peace bond, going over the client's background. So the bottom line is to try and get the Crown's bottom line about what they're offering. If they offer withdrawal, that's fantastic. We can bring the case forward and have withdrawn. Peace bond's sometimes great too, but they might not be playing ball that way, and they might be asking for a jail term. Or maybe they're offering a conditional discharge where we can avoid a record. Ultimately, I take all this information back to the client, give them my legal advice on that so they can make a decision. Do they like the Crown offer? Yeah, it's great. They're withdrawing the charge, or they're offering a peace bond. I just have to forfeit the weapon and get rid of my firearms for a number of years. Or I like the conditional discharge. Or no, they're asking for a lengthy jail term because it's a serious offense, pointing a firearm or something at someone. But I think I can win it. Let's have a trial. So I might need more than one Crown pretrial, more than one Crown pretrial with the Crown, and I may need multiple meetings with you to figure out what we're going to do. But ultimately, you tell me what you're going to do. So let's assume you tell me to resolve it because we're getting a conditional discharge for a minor weapons offense. Well, when I attend your first appearance, I've already attended it, by the way, before I met with you. The matter went over 12 weeks automatically pursuant to the designation system we have. It's a new system that was brought in during COVID. It's called an enhanced designation. Court matters automatically go over 12 weeks. As a lawyer, I'm expected to complete as many steps on the file I can in those 12 weeks. And we're now in a position to plead guilty because we like the deal. Well, I might require a judicial pretrial if I think I need approval of the deal, or it might be such an obvious joint submission that I know a judge is going to approve it and I don't need a judicial pretrial. By the way, I covered judicial pretrials in another video, which you should watch. But the bottom line here, to get judicial approval of a deal, I can meet with a judge and say, look, we have a joint submission, here's the client's background, and the judge is going to say, I like that, or I don't like that. Once we have approval, we have certainty. Sometimes you need certainty. In other situations, it's obvious where the judge is not going to jump a joint submission. And I go through these topics in other videos as well. Now, so we can move that. So when the matter went forward, was set 12 weeks down the road, if we're pleading guilty, we can bring the matter forward and deal with that. That's not a problem. So don't worry the fact that it went down 12 weeks. That's just a reporting mechanism. We're just showing up in court and saying, Your Worship, to the Justice of the Peace, I just, I've been retained. I'm going to do the steps on a file. Pretty please, can it go over 12 weeks? It's kind of a useless system. We could do this by email. We could do this by letter. I don't know why we still have this system, but we do in Ontario. And I critique that in other videos you'll see, but that's the system we have. It's just a reporting mechanism. It's kind of like reporting to your boss that you're working on the project and your boss says, what are the next steps? Okay, go to it. I'll give you another 4 weeks to complete it. Okay, that's our court system. So you can resolve it at that point. That can be done early on. And that can be done, anytime from 2 weeks to a month after the first court appearance up to 4 or 5 months if we need to do a lot of work in your file. Resolve it. Bring it into court and be done with it so you can move on with your life and hopefully get the lightest sentence we can for you. In a perfect world, a withdrawal. In a second perfect world, a conditional discharge, or hopefully avoiding a jail term. Now, on the other hand, if we set a trial date, what do we need to do for that? Well, the next step after I meet with the Crown is to set what's called a judicial pretrial, which is a meeting with a judge, the Crown and I, to talk about managing court time, estimating how long a trial is going to take. Mike, Mr. Kruse, what applications are you bringing? Are there charter issues? Are there statement issues? How many witnesses you're calling? Crown attorney, what witnesses are you calling? How long is this trial going to take? We need to analyze every step of what's taking place in the trial to come up with a proper time estimate. And we're now in a position to set a trial date. So let's say it's a 1-day trial, 2-day trial, might be longer if it's a more complex case. Our staff then reaches out to the trial coordinator, organizes the earliest possible trial date, which is commensurate with the Crown schedule, police schedule, and witnesses, and we secure those trial dates, and then we appear on the record in court at the next court appearance to set that trial date down the road. Now, when the heck is, the vexing question is, when do you get trial time in Ontario? Very loaded question. In the Ontario Court of Justice, it really depends on the county. So if you're in a busy county like Toronto or Ottawa, Brampton, these are busy courts. They're really booked. So you might get a trial date in Brampton, for example, if we're lucky, 12 to 15 months after your first court appearance, in that range. By the way, our court system requires trials to be completed 18 months from the date of arrest, or you may have a delay application as long as the delay is not caused by defense counsel. Check out my video on delay applications as well on that issue. I won't get into that here. Now, in less busy counties, maybe you'll get a trial date 9 to 12 months. In a perfect world, in some select counties which are not busy at all in Ontario, I've seen trial dates set 6-7 months after the first appearance, but that's a rarity. That may be pushing a bit. So that's the range. It's all over the map in Ontario. Hopefully it's not longer than 18. Well, sometimes you hope it's longer than 18 because you can get a delay application, but that's kind of the parameters in Ontario. We'll call it 6 to 7 months in a perfect world in a less busy county, up to about 15 in Toronto, Brampton, sometimes even up to 18 there. Now, again, the resolution's much less timeline for that. Now, those are for more minor weapons and firearms charges. For more serious charges where they've elected by indictment, for example, commission, use of a firearm on a commission of offense, a very serious offense, possession of a weapon for a purpose dangerous to public peace where they've elected by indictment, you have greater rights. You have a right to elect in the lower court, which you might. So if you elect in the lower court, Ontario Court of Justice, same timeline I just told you about, we just went over it. Or you can elect to be tried in the Superior Court of Justice, either judge and jury or judge alone. For commission of a firearm, commission of offense using a firearm, you actually have a right to a preliminary hearing as well. So if you elect preliminary hearing, it's going to be the same timeline as a trial that I just went over for, say in perfect world, 6 to 7 months, up to 15, even up to 18 months. After the preliminary hearing, if it's committed to trial, there was enough evidence to put you on trial, it's going to go to the Superior Court of Justice, and you might get your trial date on, well, they're going to have to try hard to get it under 30 months. You might get it on 9 to 12 months after that. Now, for possession of a weapon for purpose dangerous to public peace, you don't have a right to a preliminary hearing. So after about 4 to 5 months in the Ontario Court of Justice remand system, which is the same process we just went over, you file an election document to move into the higher court, Superior Court, and it goes directly to trial. So maybe in a perfect world, you might get your trial date 12 months after that or longer. It could be up to 36 in a busy situation. If it's a jury, God knows when they're going to start because they're paused during COVID. But it wouldn't surprise me at all that a case is going to take at least 30 months when you've elected up Superior Court, particularly when you've had a preliminary hearing. But even when you haven't had a preliminary hearing, it takes much longer. But sometimes strategically, it's important to go to the Superior Court of Justice. You may have a more liberal bench there, or you may want a jury trial, or you may want the strategic advantage of a preliminary hearing. Every one of these little issues that I've talked about, from the first appearance, disclosure, defense counsel giving opinions, Crown pretrials, you name it, judicial pretrials, the trial process, what happens at trial. Every one of these is covered in other videos. I just wanted to give you an overview of what we tell the client very early on in our process, and constantly, frankly. And we also tell the client about every one of these other issues as the file moves along, what it means and because a client, information is power, and a client needs this to alleviate their stress so they know we're moving their file properly. It takes time though. Don't think that the court system happens overnight. If you've got a winning case, it can take up to 36 months in the Superior Court of Justice. It can take up to 18 months in the Ontario Court of Justice. It's not going to happen next month. And resolutions sometimes take time too. We need to sometimes put our ducks in a row where weapons get destroyed, where you might have to get counseling and whatnot. So there's the typical court process for a lesser weapons offense and typical court process for indictable weapons and firearms. And I hope that provides you some useful information if you're charged with these type of offense, or even if you just follow the criminal court system out of interest. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.